Barristers, I indicated before, Conor O'Sullivan came to the bar having signed the roll, having been admitted, I should say, in 2007, came to our list in 2010 and practices extensively, but not exclusively, insofar as the Magistrates Court and County Court and Supreme Court indeed, but involving matters of compensation, and I just invite him to pass on his experiences to you, which I'm sure you'll find very helpful.
With the time we have left this morning, I wanted to talk about three cases, recent cases that have dealt with medical panel referrals. The first two deal with judicial review of medical panel decisions and reasons, and the third is a decision of Magistrate Garnett dealing with whether factual disputes can, or whether it's appropriate to send factual matters to the medical panel. The first case is Department of Human Services and Kotzman and others. This was a decision of Justice Kairu earlier this year. This case involved a claim by a worker who had injured her right knee in the course of her employment with the DHS. She had lodged a claim for weekly payments, which was accepted, and she remained on payments until January 2011, when they were terminated on the basis that we often see, where the worker had received 130 weeks of payments, and it was asserted that she now had a current work capacity, or alternatively, if she didn't, that situation was not going to continue indefinitely. What had also happened in this case is that subsequent to being on payments and to no longer working with the DHS, the worker had sustained a right shoulder injury and then a left shoulder injury and also some lower back pain. She issued proceedings in the Magistrates Court, and questions were referred to the medical panel. The questions that were referred to the panel are the questions those who work in this area would be very familiar with. What was the nature of her alleged injury? But then the sub-question to that, as I've reproduced in the paper, is what was the nature of the condition resulting from the accepted work-related injury? And then the sub-question, what was the nature of the condition relating from the alleged injuries that had not been sustained in the course of her employment with the DHS. The panel was also asked whether employment had been a significant contributing factor to those injuries. The panel was asked whether the worker had a current work capacity or no current work capacity, and whether, if she had no current work capacity, was that going to continue indefinitely. In summary, the panel found that the worker was suffering from degenerative osteoarthritis of the right knee and from a medial meniscal injury, and that was relevant to the claimed injury. That was a condition arising from her compensable injury with the DHS. The panel also found she was suffering from a chronic adjustment disorder with depressed mood, and that was a consequence of the right knee injury. The panel also found she was suffering from bilateral shoulder dysfunction as a consequence of bilateral rotator cuff disease, which was not relevant to the alleged injuries. And finally, the panel found that her employment with the DHS was a significant contributing factor to the right knee injury and to the development of the psychological consequences, the chronic adjustment disorder with depressed mood, but not to any injuries to any of the alleged injuries to the shoulders. The panel also found that she had no work capacity and that was going to continue indefinitely. So on the basis of the panel's decision and reasons, the worker was entitled to ongoing payments. What the panel had done and what was made clear in their reasons was that when considering whether this worker had a capacity for suitable employment, the panel took into account many of the factors that they are required to under the definition of suitable employment, so her age, her education, where she lived, what transferable skills she had, but the panel also took into account her bilateral shoulder condition and her lower back pain. The DHS sought judicial review of the decision, and there were 3 grounds. The first 2 dealt with jurisdictional error, and the third and final ground was that the reasons given by the panel were inadequate reasons. In terms of the jurisdictional error grounds for review, it was said by the DHS that by considering the worker's supervening bilateral shoulder conditions and the lower back pain that were clearly not compensable, that the medical panel had erred. And the DHS was successful. Justice Kauru found that the panel had fallen into jurisdictional error. In terms of the submissions that were made to the court, the DHS relied on Ward's case, which is the 1938 decision of the High Court. And if any of you have never read Ward's case or have sort of lost familiarity with what it's all about, there's a very useful summary of what comes out of Ward's case in this decision of DHS. The DHS relied on Ward as proposition that when you're assessing incapacity as a result of compensable injuries, then you're not to take into account supervening non-work related injuries and any consequences that flow from those. The worker, on the other hand, submitted that that's not the case and said that no current work capacity, the definition of that in the Act, requires that when you're considering a worker's ability or inability to return to work in either the pre-injury employment or suitable employment, that inability must arise from or be materially contributed to by a compensable injury. And really, the worker relied on the words arising from and said that those words do not require the exclusion from consideration of a non-compensable injury. So in effect, you're looking at the total picture and you should be able to consider supervening injuries even if they didn't happen or arise from your employment. Justice Kauru said, disagreed with the worker's submissions and said that in order for the worker to be entitled to continue to receive weekly compensation payments, it was necessary to satisfy the definition of no current work capacity by establishing a present inability arising from the right knee injury and anxiety and depression. His Honour rejected the submission made that there's a fundamental difference between the phrases results in and arising from, so that in effect what the worker was saying, as a result of those words, the principles in Ward's case don't apply, and His Honour rejected that submission. There was also argument put by the worker and reliance on some subsequent cases to say that the principles in Ward's case had now been bypassed in Australia. His Honour rejected that and said that Ward's case is still good law. What comes out of this case, and I think what to look for if this sort of situation arises, is that it was relevant that the panel found that the separate injuries affected separate work capacities rather than one work capacity. So the panel concluded that the worker's right knee injury affected her general mobility, whereas the bilateral shoulder condition and low back pain affected her capacity to undertake physically demanding work. So there was a separation of the effect of the compensable injuries and the effect of the supervening injuries when considering the total picture of whether this worker could get back to suitable employment. The second decision, this is a decision of Justice Kavanagh Barrett, Barristers, Malting Company and Cotsman and others. This deals with a slightly different ground of jurisdictional error where, oh sorry, not jurisdictional, a different ground for review where it was argued that the employer was not offered procedural fairness. In this case, the worker lodged and had accepted a claim for injury to the left wrist and hand, which occurred in the course of his employment, and he went on to receive weekly payments for over 12 years. When the payments were finally terminated, it was on the basis largely of some surveillance footage that had been obtained of the worker, which showed him, on my reading of the case, not doing anything overly physical, but things that were clearly inconsistent with what he'd told doctors and what he'd said he could do. The surveillance seemed to show him removing some items from the boot of his car using the left hand, closing the boot of the car with his left hand, and also driving his motor vehicle, which I think was something he had said to a number of practitioners that he couldn't do. This was a matter that was referred to the medical panel direct by the conciliator rather than one that had come following the issuing of Magistrates Court proceedings. The questions for the panel were again whether the worker had a current work capacity and also whether the injury that he was claiming had been contributed to by his employment, or his current incapacity, whether that was contributed to by his employment. The panel found that the worker was incapacitated and that was materially contributed to by the claimed injury to the left hand. In its reasons, the panel had it was constituted by physical and psychological, psychiatrists, medical practitioners, and they'd conducted a mental state examination and said, and I've reproduced it there in the paper, taking account of the nature of the worker's psychiatric condition, the panel concluded that the worker is suffering from persisting dysfunction of the left hand and forearm, which is attributable to his current psychiatric condition of factitious disorder. And the employer probably quite understandably took issue with this diagnosis by the panel because it hadn't been said by anyone prior to the worker going to the panel that he suffered from a factitious disorder. None of the medical practitioners had come up with that diagnosis at all. The employer, in its submissions to the court, said that the findings could never sustain a determination of compensable injury or disease, and the employer referred to DSM-4, which has a definition of factitious disorder, and noted that the panel in its reasons had not even referred to that definition contained in DSM-4. The diagnosis of factitious disorder under the DSM-4 says, characterised by physical or psychological symptoms that are intentionally produced or feigned in order to assure the sick role, and that the diagnosis is excluded, and this was important, where there are external incentives for the behaviour, such as economic gain, avoiding legal responsibility, or improving well-being. The employer placed a lot of emphasis on the panel not referring to DSM-4 and made the point that when a person or when a plaintiff alleges that they suffer a psychiatric disorder that's referred to in that manual, then typically the position in Victoria is that the condition should be established in accordance with the criteria for that diagnosis in the manual. Ultimately, what the employer said was that they'd been denied procedural fairness because the diagnosis of factitious disorder, it couldn't have been anticipated when all the diagnosis to date had been that the worker had an adjustment disorder with depressed mood and anxiety and depression. the point was also made on behalf of the employer that the finding by the panel that the worker had this factitious disorder, notwithstanding that the panel had also found that the worker was motivated by significant secondary gain, meant that that was completely inconsistent with the diagnosis or the diagnostic criteria in the DSM-4. His Honour agreed that the panel's diagnosis was, in his words, unexpected and could not reasonably have been anticipated, and that the employer was denied a fair opportunity to address the matter. His Honour said that the diagnosis came out of the blue. There was then at the end of the decision, a bit of a discussion about factitious disorder generally and whether it could be a compensable injury. And submissions weren't made on it, and His Honour didn't make a ruling, but he did discuss it, and he said that he'd formed no definite or even provisional views as to whether a worker might be entitled to statutory benefits if he were properly found to be suffering from a factitious disorder as defined in the DSM-4, or if their presentation was partly motivated by secondary gain. It's probably not a situation that's going to come up all too regularly in practice, but is just an interesting example of where the panel goes out on its own to an extent with its diagnosis, and that can be a ground for judicial review if it happens. Also, if anyone has a case where factitious disorder is one of the diagnoses offered, it might be interesting case to run to see whether it is held to be a condition that can be compensable. Steel and line forklift services was a case where the plaintiff had applied to refer questions to the medical panel, and the defendant opposed it on the basis that there were substantial factual issues in dispute and that those should be determined by the court as opposed to by the panel. The decision in Steel is a useful one to read because it sets out the regime under the Act for the court when dealing with medical questions and this issue of when matters are more appropriately dealt with by the court. And it's quite a flexible regime in that it effectively allows the court to send all questions to the panel, partially decide some questions itself and then refer further questions to the panel, or ultimately decide this is a matter that in its entirety should be decided by the court. This case again involved issues that arose from surveillance, and it also involved issues where the plaintiff had sustained further injuries as a result of separate employment that weren't part of the initial claim. Magistrate Garnett, who decided this case, said the issues of what injuries the plaintiff sustained in his separate occupation, he went on to work as a stuntman, and also the activities that the plaintiff was seen doing on surveillance and how those matters affect his credibility are essentially factual issues that are more appropriately determined by the court after hearing the plaintiff's evidence and the testing of his bona fides in cross-examination. His Honour said, in his opinion, it's not appropriate to refer questions to the panel when significant issues affecting or which may affect the worker's credibility are raised. He made the point that the panel won't have the benefit of the plaintiff's account being tested in cross-examination. And he also said the medical panel is not equipped, nor does it have the expertise to deal with those issues. And So in Steele, the plaintiff's application to refer medical questions was refused. They are just three recent decisions regarding medical panel referrals. We thought it was relevant to touch on some medical panel cases today, as we are seeing more and more cases go to the panel, particularly at the end of the second entitlement period, the 130-week terminations. So that brings it to an end, Paul, unless there's questions for...
Yeah, thank you very much, Conor. Good on you. Thank you, boys, for that. What we thought we might do is to provide an opportunity for anyone who'd like to ask the panel some questions arising from any of these matters or associated with these matters. And I'll invite you to do so. Just while I'm here, to one or other of you, what occurs when the defendant asserts that the injury was not sustained in the course of employment, but an agent has decided to make payments to the worker? How can that possibly get to a medical panel to determine his entitlements when the defendant says, well, our evidence is that he was not injured during the course of his employment?
Well, I think the answer to the first part is the question of whether it happened in the course of employment. If payments have already been paid, probably can't go to the panel. The question that could go to the panel in that circumstance would be well, there could be a question whether employment continues to contribute to the claimed injury, and also whether the worker is entitled to continue to receive compensation by way of payments or medical and like expenses. I think if it is at that stage alleged that employment is not contributing, that employment did not cause the injury in the first place, I think it's unlikely that that question will go to the panel. Bruce?
That's right. You can... Is that working? The acceptance of the claim will be held to be an admission. The employer can seek to reopen that issue if they say it was done under a mistake, and then it all starts afresh. And
how does Ansett and Taylor operate then?
Ansett and Taylor works. You can that's evidence of the admission, or that stands for the admission. What's been considered in that's usually a bit further down the track. The Ansett and Taylor, that's after the primary claim has been accepted for the weekly payments or the medical expenses. It remains a problem. The agent might have some explaining to do, but it can be explained if it was done under a mistake. If, for example, if the agent didn't have access to clinical records of the treating practitioner, or there wasn't a particular employer witness known of or available, there's room to argue it. It's been successfully done in the decision of Kerridge. That's the one that we all know about in another context. It's a decision of Judge Bowman, and another one of His Honour Judge Roland Williams of the County Court in a matter of Castillo. So you can reopen the issue, but it needs to be done on evidence. And once you've got reopened the issue of whether or not it happened in employment, then the decision of Justice Ashley in Kavanagh, number 1, I say that because there are 2 Kavanagh decisions, at about paragraph 74 to 76 says that you can't use the medical panel of dealing with this as a backdoor way of dealing with the issue of whether or not the injury suffered in employment. So it's a long way of saying that it ultimately won't go. And then, of course, apart from all of that, you've got the provisions that Conor was talking about in terms of factual disputes. So it'll be stopped at the barrier there.
Yeah, I see. Would anyone like to ask either of the boys a question? Yeah.
I just think I haven't understood something properly, but in the DHS case, are we saying that you must consider what the worker could do in terms of suitable employment at the time that they are really sustain injury rather than at the date of determination of what's suitable employment? Because it seems from what you're saying that, let's say I had a knee injury in 2010 and I went blind in 2012, we don't, when looking at suitable employment, take into account the fact I've gone blind, but instead look at what I could have done if I hadn't gone blind. And as I said, I'm confused about this, so I probably just put that very confusedly.
I think, in effect, what you're saying is actually right. I mean, it's an extreme example, but what Ward's case and now what DHS and Kotzman stands for is you cannot consider supervening injuries that are non-compensable in assessing current work capacity, considering current work capacity, you need to look at, of course, suitable employment and the definition under the Act. It's an extreme example, but I think on my reading of it, Bruce, and you can tell me if you think I have this interpretation wrong, but that is the case, because the employer should not be liable for supervening non-compensable injuries down the track.
The point, if I can assist, the point is clarified when you look at the injuries at the bottom of page 14 of the paper. The point that Conor makes is that rather than finding the separate injuries, both compensable and non-compensable, affected the one set of work-related acts, another way of looking at that is the trigger for entitlement to weekly payments is incapacity resulting from or materially contributed to by, in brackets, a work-related, close brackets, injury. Provided the work-related injury results in or materially contributes to the incapacity, that's enough. You can have other non-work-related conditions resulting in or contributing to the incapacity, that doesn't matter. All that you need for the worker is that thread of the work-related injury resulting in or materially contributing to the incapacity. So in the DHS case, had the medical panel found that the knee injury, which was the compensable injury, also affected the capacity issue in a more direct way, then it would have been sufficient. It seems that they separated out mobility versus physically performing the work, and presumably in that DHS case there was a suggestion that the worker could do process work or so on where there wasn't any particular requirement for mobility. So the short point is compensable injuries and non-compensable injuries can all go into the mix provided your compensable injuries result in or materially contribute to the incapacity.
Yes.
There was a previous decision from Justice Judd on a similar issue, either late last year or early this year, the name of which escapes me. But that too involved a 130-week termination. Would you both agree that sort of the principles outlined by Justice Cairo apply in the first and second entitlement periods as well?
Yes.
I think Minter-Ellison and Kotzman, is that the new thing? Yeah, and the difference with Minter-Ellison and Kotzman and DHS and Kotzman, I think in Minter-Ellison and Kotzman it was conceded by the workers' representatives that supervening injury should not be taken into account, whereas in DHS and Kotzman that wasn't conceded, and in fact the alternative argument was run.
Anyone else? Okay. Well, thank you very much for all coming. Thank you, boys, for enlightening us. As I said, on behalf of Greens List, we're very happy to have these seminars and discussions and chats. And I thank you all for coming, and I think we might have a cuppa or something. Is that right? Okay. Thank you very much. Thanks for your attendance.